Evening, everyone. Just bear with me whilst I do the couple of bits. Hope you haven't melted yet. With no Will tonight, he has actually melted somewhere in London. So hopefully he'll be a pool of water on the floor somewhere. Um, and to be honest, I don't know if he's going to be. I mean, because we've got this heat wave for the next couple of weeks. I don't know if we're going to see much of him. We'll see. But yeah, as always, this is not legal advice. We're going to do our best to be helpful. And as always, please do not ask questions in the first person. That is to say, hey, you're right, Michael, you're right, Tiff. That is to say, ask questions as if a what if question. You get exactly the same answer. It cuts out a lot of complications as well. Plus, yeah, plus you don't have to put your data online, which is awesome. Which isn't the only reason, but it's a good reason. Let me just double check I haven't missed anything. That's all good. So we've had 4 questions in from the week, two of which were anonymized. So we'll start with those two. We'll then get into the live stream, and we'll then come back to the other two. So what else do I need to say? As always, just I mean, I'll say at this point, I don't know how much people listen to me on this, but we've had quite. Hey, you right, Martin? We've had quite a few live streams recently where we've run out of time, as in like more and more questions are coming in, and I've just had to kind of basically just end it because we need to finish at 8:30. So the only way you can guarantee to get a question answered is if you put a question on any video on the channel, and I'll then get a notification and I'll bring it here. So this is what these 4 questions have done. They've basically gone on the channel, they've asked a question. So that's the way that works. Other than that, I don't know if you guys have got any gossip at all. I'm trying to think like I saw an interesting thing actually, very quickly. There's someone doing a campaign somewhere. Now it's got a very slim chance of going anywhere, but I thought it was actually quite sensible where although Section 21 notices are Section 21 evictions are going to be a thing of the past, there are still going to be plenty of no fault evictions. Yeah, because they still are going to happen. But someone was basically saying that landlord, like basically tenants shouldn't have to pay the last 2 months of their tenancy because they're trying to find something else. And I just thought actually that's quite a sensible way of doing things. Now I'm sure landlords won't like it, and I'm sure they'll kick up a fuss. But it just seemed, yeah, kind of to recognise the fact that it's incredibly unsettling and disruptive to basically give someone a notice. And it kind of goes back to the idea that actually a tenancy is first and foremost someone's home rather than just someone's like money making scheme on the side. So yeah, hey, right, Stacey. So yeah, I just thought I'd say doubt it's going to go anywhere, but it was just I thought quite a smart sort of idea really. And I feel like there's been some other news this week, but I don't remember what. But yeah, unless Shannon and Karis have got anything they want to say at this point, we'll go for it. Hey, right, Katie. So question one, let me get the screen up, is as follows. Um, can you please explain that if someone lives with their cousin in their cousin's house for 9 years, does the cousin, the owner, need a court order to remove them? Council's referring to Housing Act 1977. So I didn't have time to go back to this person to get clarification. My understanding is, and Karis will know better than me and Shannon do, but effectively, if the cousin actually lives in this home and this other person is basically living there, has been paying rent or whatever, then they'd be a lodger, and so they don't have any kind of protection under the. I guess this is the Housing Act 1977 is where that comes from. So in which case, yes, if they're a lodger, then yeah, they need to have a letter and they need to have I think like reasonable time to move out, which I think is could be as little as a few days sort of thing. I don't know exactly what's scale set out. But if the owner doesn't live there, so they're not a lodger, so they're actually a tenant. Again, it doesn't really matter whether there was an official tenancy. If someone's been paying rent regularly, particularly if it's for 9 years, then they get protection from as a tenant. And so the cousin would need to evict them according to the Section 21 process or the Section 8 process or whatever. Um, so I think it sounds like the council was probably right. The council was probably saying, no, your cousin needs to actually evict you legally because you have protection as a tenant. It's not relevant that they're a family member. So that's my understanding. But Karis, you deal with this sort of stuff much more than I do. So I don't know. If what I just said just right there, and is there anything you want to add to that at all?
Well, I'll just explain the Housing Act. You might be referring to the Protection from Eviction Act 1997, which is they can't unlawfully evict you. But it does depend on what you mean for the grounds you're at your cousin's house. If they've left and the tenancy was in your cousin's name, you don't actually have a right to be there. So you're technically a trespasser at this point if you just carried on living there, paid the rent, but you don't have a contract with the council with the landlord to be there. So therefore, they would go to court and get you evicted on the grounds that you don't have to be here, and you would that would be likely to be quite a quick eviction. It could even be within 24 hours because you have no right to be there, which is no consent from the landlord to be there. And the same with the lodgers. They would give you like a notice to quit, so that's usually 28 days, but they could give you like 2 weeks. And the court um would have to grant this as well. So it depends on what grounds you're there. And what did you ever speak to the landlord? Did the landlord know you were there? It will all come under that.
I mean, the way I'm reading it is that the cousin actually owns the property and they've been renting it out. That's how I'm reading it. But again, you sometimes it can be lost in sort of
Yeah.
in
So if
translation or whatever.
yeah, and if the cousin is the landlord, what agreement did you make, whether it's verbally or he would have to get a court order to evict you. But if you have no grounds to be there, like you didn't pay rent or have an agreement, is what grounds you're there for.
I mean, if you go to a council in that circumstance, they really should be more helpful than just sort of like swatting you away and saying,
Yeah.
they should explain it. So there's no point saying, oh, the Protection of Eviction Act 1977 or whatever. They need to actually say, like, this is what, this is, even if it's just giving you a pamphlet and saying this is what your rights are, this is what this is what your landlord needs to do. So yeah, but anyway, hopefully that answers the question. And again, if whether it's a family member or not, if a landlord starts putting pressure on you to leave, go back to the council and say, my landlord's harassing me, my landlord's kind of trying to illegally evict me, because because the council can do quite a lot there to kind of actually stop it happening. The worst thing you want to do is just basically leave, because effectively what's happened there is the council's told you you have a right to be there, stay there until you have a proper Section 21 or whatever. If you were there to then leave, they could say, well, we told you what the right advice was, you ignored it. You run the risk of being intentionally homeless then. So yeah, Shannon.
Yeah, I mean, I just want to. It's probably less helpful for this question, so apologies. But like, it's only because I was actually looking at it today in the Code of Guidance. But 9.9 in the Code of Guidance, the duty to provide advisory service. The housing authority has a duty, so something they have to do to provide advice and information about homelessness and the prevention of homelessness and the rights of homeless people or those at risk of homelessness, as well as the help that is available from the housing authority or others and how to access that help. The service should be designed with certain listed vulnerable groups in mind, and authorities can provide it themselves or arrange for other agents to do it on their behalf. So it's not helpful for this case, but I just think if more people were to complain and they've gone, oh, I've gone to the housing department at the council and they like basically battered you away in this situation, then that's like a really quick complaint of like, actually, you have a duty to do this. I'm now left more confused and whatnot. I do wonder if it would sort of, yeah, maybe that's too big a picture for tonight. Sorry.
No, no, no. Look,
Okay.
we're here to learn, aren't we? This isn't just the point of doing this way is not just to answer individual questions. It's to share knowledge out. That's the point. And so you're absolutely right. I think that's a really like systemic issue to kind of to raise and kind of tell people they can go after it in their own area. So it's good. Yeah. Um. So yeah, I think that's it. And for those asking about these crowns in the live chat, I've got no idea what that means. Looks cool. So well done if you've got a purple crown, and you seem to be ranked as well. Don't know what that's about, but yeah, hopefully it makes sense to everyone else. So that's question one. Question two from the week is this one here, which is a question relating to Section 21s again. So what happens when your Section 21 runs out on a Sunday due to do the temporary accommodation team get in contact and complete a risk assessment, then offer temporary housing as one would be classed as priority need, or would you need to get a hotel? So maybe more than one question going on in this sentence. So just to say, I mean, I mean, it's going to be an academic point soon because Section 21s won't exist, but I'm sure there'll be a similar kind of battle with Section 8s and other kind of evictions anyway. But basically, it is likely that you are homeless the day after the Section 21 expires, or I guess the day the Section 21 expires. So that, yeah, that could well engage the interim accommodation duty, because if you've got kids and you're eligible, then there's going to be reasons people might be homeless, might be eligible, might be in priority needs. However, it is more complicated than that. We've got extensive videos on the channel which we go through to explain that in more detail. So if you search for the term bailiff on this channel, you'll get 3 videos at least which kind of go through it in more detail. The reality is, if your Section 21 ends up on a Sunday, I doubt very much a council team's going to ring you up on a Sunday to kind of arrange a hotel or interim accommodation for you. Even if they're a good council who's following the law, they're probably going to wait till a Monday. And in one sense, they need to kind of assess a few things. So, can the landlord be bribed or whatever to keep you for longer? That's one of the things they need to look at. Was the Section 21 valid? Those kind of things are relevant. But even if the criteria set out in 6.35 of the Code of Guidance is satisfied, then yes, the council may well then have a duty to provide interim accommodation. But no, they're unlikely to do that out of hours, so to speak. So if we go to let me just unshare this screen and share a different screen. So I'm going to probably refer to this once a week because it is a good resource. I'm hoping you can all see that. This is a database of LGSCO, local government social care ombudsman decisions. They're mostly upheld ones, and I've put these together because they're useful. So if we search for the term Section 21, feel like there's so this is one example of many. So what you do with this is, this is London Borough of Barnet. You've got the summary here from the LGSCO. If I just briefly go to LGO decisions, on a sec. Yeah, sorry, the way Zoom works is I can't actually see everything all at once, which is quite annoying. But basically, so if we go back to the database, there's this number here, which if we copy and paste that, and we stick it in here, we then get the full decision. So here it is, London Borough of Barnet. And you've then got, what is really good about these and why I've bothered doing this is that in the LGSCO reports, you've got effectively, what's the law around this particular issue, and so they kind of, this is solid stuff. Kind of looks at a few other things that are relevant, then goes through what happened, and then kind of comes out the decision. So essentially, what happened here is the council told them to wait after the Section 21 expired. There wasn't a good reason for it, so they get £500 compensation. And in some other cases which are on there, you basically get the court cost as well. I'm trying to think that I'm sure that there's more on it than that. So let me just search for the term bailiff on here and see if we get more hits. Yeah, there we go. So yeah, in fact, we've got quite a few here. So again, you can do the same thing if you go on the if I just put this database thing into the chat. But yeah, you can kind of go on there and have a look at it, and you can find out for yourself. So I'm a painter and decorator. This is where I learned about this stuff. It's on the LGSCO website, and so that's why I've kind of put that stuff together, because you can then go and find out, okay, what was the principles at stake here. And so going back to our actual question, or part of the question, because there's a bit more to it, I think. But that kind of what explains, if you go to the LGSCO decision database, or you look on the channel for the videos about bailiffs, then you'll get the explanation. And then there's another aspect to the question here. So the risk assessment is not a legal thing, but councils obviously will generally do one. So temporary housing, so again, we need to be pedantic because it's the law. At this point, it's not temporary accommodation, although many people, including myself, will call it temporary accommodation or TA. Technically, it's interim accommodation at this point. It is the accommodation you get in the interim between making an application and a final decision been reached. And then it would become temporary accommodation if you're owed the main duty, for example. So, and interim accommodation can be any accommodation that's suitable, but because it's for such a short, or should be for such a short time, hotels are one of the options councils can use. So there's no kind of legal difference between a hotel and other types of interim accommodation, other than the fact that, for example, councils can't place families with children in a hotel for more than 6 weeks, or B&Bs technically, but that would include a hotel. And interesting today, again, if you go on the LGO website, so lgo.org.uk, you sign up for the newsletter. There was one today I saw where someone got £4,500. I think it was Oxford Council. They got £4,500 or so because the council had kept them in a hotel for more than 6 weeks. They had kids. That was the end of it. That was that simple. So yeah, I don't know. I've kind of just waffled a little bit there, but that's where you find out more information. And I'm hoping that answered both kind of aspects of the question there. Shannon and Karis, did I miss anything, or do you want to add anything to this at all? No, cool. Okay. So that was the two anonymized questions from the week. I'll come back to the other two questions later on. So if we go back through the live chat, um, here we go. If a person isn't, is this multi-parter? I think it might be. Hold on. Just get it all together just in case. And just to reiterate, guys, just another benefit of putting the questions in advance is that you don't have a character limit, so you don't have to put it over three things. But here we go. So if a person is in the process of a Section 204 appeal and the council replied with a minded to uphold letter of a under Section 2 under review Section 202, what are the chances of changing a decision? Can the council settle at any stage of the Section 204 appeal? As the council missed the deadline of the review section of the 202, and there's lots of medical evidence, are they still quite likely to go all the way to court to the actual hearing? So this is a question, obviously, we can only speculate because we don't know which council it is, we don't know which officer it is within the council. But certainly the fact that a council didn't uphold or didn't overturn the Section 202 stage, just to go back to basics, you make an application, the council make a final Section 184 decision, which you can challenge through the Section 202 process. So then you kind of, then the council look at the decision again, basically a more senior person often, and then they reach another decision. Did they uphold it? As in, did they say, yep, the first decision was right, or did they overturn it and say, no, the first decision was wrong. We've accepted that this person's in priority need or whatever. But if the Section 202 decision is the same as the Section 184 decision, then the next way to challenge it is to go to court through the Section 204 process. I guess, at this point in time, councils generally will be weighing up their chances. So if they think, no, we think we've got a pretty good case here, we think we've got a pretty good chance, they might basically just kind of play hard to get sort of thing and just wait for it to go to court. There are plenty of situations, and again, so Will's been doing this for decades, whereas Karis is newer to it. So Karis, you might not have as many examples of this, but there are many situations where literally just before the court date or whatever, the council will fold and say, yeah, fair enough, we'll house you. But that's possible. So in one sense, it's impossible to kind of give you an exact answer here, but I'd say there's a very plausible chance that things will go your way in this situation. But it obviously depends on the facts of the case. But council's consideration of medical evidence is often very bad. So if you've got lots of medical details or whatever that's not been taken into account, I'd say on the face of it, there's a good chance of getting overturned, but obviously we can't guarantee anything here. So, Karis, do you want to add anything to that in terms of detail or other bits and pieces?
Yeah, I'll just say, well, like you said, it's the stages. So on the application, and then they make the Section 202, and they can settle at any stage by accepting it. But it's producing the medical evidence, and what the Section 204 appeal is, it's not about the medical evidence or anything like that. It's how they've come to the decision. So it's what you're appealing on the error of law.
It gets quite. We saw this in the case earlier this year, which was Ivory v. Welling Hatfield. It gets very intricate, basically, because in that case, yes, the 204 appeal was about, did the council follow the right, did they, as Kara says, did they kind of make the right decision for the right reasons based on the information they had at the time? And actually, in that case, yep, they were found to have actually made the right decision. But whilst that was all happening, the solicitor then went and got more medical evidence, which technically they weren't allowed to submit to the 204 process, and then they just made a fresh application the day after or the day of the negative Section 204 appeal. So there's lots. I mean, yeah, as I say, if I was a betting man and I saw a council make a decision based on medical evidence, I would bet a lot of money that whichever council it was, probably messed something up somewhere. They overlooked something without a good reason and so on or whatever. So yeah, hold on in there. I think a lot of councils just basically, as I say, they kind of hope that someone's going to give up. And if they realise someone's serious about going all the way, they'll back down often, but not every time. So again, we can't give absolutes here.
Yeah, and it's a fail to consider the relevant evidence. So it's a fail to consider what they've done with the medical evidence, whether they've ignored it completely, applied to higher threshold or got the common one as now medical to look at it. So they have their own advisors and get them to look at it rather than talking to your doctors.
Yeah, I mean, so yeah, I mean, I mean, there's loads of examples of now medical kind of doing things which are pretty questionable. I remember one which was talked about by a barrister called Nicholas Nicol, where the now medical basic it was involving a kid with like some kind of special needs, and kind of meant that they weren't very good at kind of being aware of dangers. And effectively, what now medical said was, yeah, the kid might fall down from their floor, but it's only like a two-story drop, so it's probably not going to kill him. So it's kind of okay. So you kind of get ridiculous kind of things happening. So yeah, now medical, in my experience anyway, is very easy to challenge. Partly because now medical, as far as I know, is their standard practice never actually look at the full medical records. They never actually assess the person. So it's just a bit of a game that councils kind of play in my opinion. Um, cool. So hopefully that's I don't know. Hopefully that's reasonably reassuring. As I say, this someone in this situation is certainly kind of there's a good prospect of them getting a good decision at the end of it. Um, Next question. And so far in the live stream, I'm not seen any non-anonymized ones. So thanks very much for that. A family with young children in TA don't have hot water or central heating for over 3 months. What can they do? So if we go back to our LGSEO database, um, and I've searched for the term disrepair. So we've got again shitloads of reports. The first one that pops up, unsuitable TA, disrepair in TA, that says. And again, if we just get that code and take it to the search database on the LGO website, I'm pretty sure they would have got compensation for this as well. Because generally speaking, you can get reasonable amounts of money for it when they failed. But again, I mean, I don't know. Yeah, £2,600. I don't know how long it was for. So what's the actual complaint? Significant. So the issues. Well, let's go back to what the actual compensation because it says a bit more stuff. So in this case, there was other things as well happening. So there's a risk of domestic abuse there as well. So it looks like here they got £200 per month that they're in accommodation where there was these disrepair issues. But again, if you want to find out more, then go on the database, search for disrepair, and you'll find that again, we've got one here involving TA. I think most of them involve TA. There are a few involving private landlords. So damp and mold in TA, that kind of thing, £2,000 compensation. So there's a lot of stuff on there which you can read through, and it's written in layman's terms. So yes, it's not the simplest read ever, but it's I think certainly it's kind of designed to be accessible to people without specialist legal knowledge. So yeah, here's another one you knew and 1,500 quid or whatever. So yeah, that's that. The answer is complain. Get as much evidence as you can along the way. Make sure you've actually raised it, logged it, and stuff. So keep raising it. I would probably escalate it to a counsellor as well, just to kind of get their input. But yeah, that's the answer really. The council, they have to provide suitable accommodation. Any accommodation they provide has to be suitable, and clearly accommodation where you can't heat water is not going to be suitable. Obviously, there's probably if the boiler breaks, it takes a week or something to fix. That's reasonable. But if it's taking 3 months, then that's obviously not. Just to say, guys, if you find this useful, give it a like, and if you haven't subscribed yet, you'll get notifications of new videos. So feel free. Next question. Okay, right. No, it doesn't sound right. Let's get it up. Hold on. Question 5. Council stated to a friend that they accepted a homeless application from her, but they're forcing her to sleep rough to prove she's homeless. Does this sound right? Absolutely not. This is bullshit, basically, but it's common bullshit, unfortunately. It sounds like that they're having to verify she's rough sleeping. So where do we start with this? Um, it's not for the applicant to prove their case. That's the principle. I forget, is it? I forget which is it. Gravesham XP Winchester or one of those kind of standard cases where it's clear that if you go to a council and say, "Hey, I'm rough sleeping," or "Hey, I'm experiencing domestic abuse. Can you help me out with housing?" The low thresholds are basically satisfied, and you don't have to prove your case. So you should never have to go and rough sleep to prove that you're rough sleeping. yeah, there's other yeah, there's it gets more complicated than this because lots of charities kind of run this sort of gig, and yeah, it's just a mess. But yeah, I think I mean, what I'd say is in terms of practical, what you do is make the application via email. So using the steps that I've set on the channel. So there's a video on the channel called "The Best Way to Make a Homeless Application." Have a look through that, go through that, follow the steps. That basically puts you in a situation where it would be quite easy to challenge it because what often happens is someone goes into a council and says I'm rough sleeping, and they verbally say, "Yeah, go rough sleep again. We'll come and find you." And there's no record of that conversation ever, and that makes it very difficult to challenge. So what you want is proof that that's what the council said. I'd be pretty surprised if a council put that in writing. Some councils probably still would, but it'd be pretty stupid because it'd be very obvious kind of proof of gatekeeping. If you ever got to the LGSCO, they'd basically uphold it, guaranteed. So yeah, um, Shannon.
Yeah, I was just gonna, I guess, without trying to be patronising or whatever, remind people what a homeless application is. Because I guess one of my concerns here is that potentially they've made a Part 6 homeless application, and that's how they're getting away with going, oh yeah, we've accepted your homeless application, but we now need to like prove that you're sleeping rough. But it's just you're approaching the local authority and you've given them reason to believe you might be homeless and you've asked for help. That's it. That's you've made the homeless application then and there. Um, it's not some online form and lots of like bank statements and stuff. That all comes way, 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 way later. So just in terms of that and sort of like, they have to do everything in writing. So they need to provide you with sort of letters and whatnot. So if they weren't to accept that application, you should have got a decision in writing. Um, so whilst you go through the process, just ask for absolutely everything. I know, Mike, you've already said this, but ask for everything in writing, do everything in writing, um, and take your friend with you. I'm aware, obviously, we've asked people not to say an I. So, but if you've got a friend, genuinely, um, take someone with you, just to sort of be that second pair of ears and eyes.
Yeah. So skilled sort of some of the bad housing officers, there's plenty of good housing officers, but some of the bad housing officers are very skilled at weaseling out of these duties. So although the threshold's very low, there's a number of tricks they'll try. This is one of them. Yeah, go rough sleep, or rough sleep for outreach team will come and find you. So you kind of you have to kind of go into this process knowing that there's a game to play and you're going to have to challenge probably some of the kind of decisions by council. That's just the sad reality of it all, really. So yeah, don't there are some councils in the country where they do a good job, and there are some housing officers in some of the bad councils that do a good job. But again, if I was a betting man, I'd say most approaches that to most councils result in just unlawful stuff happening immediately. And so by putting these methodical steps in place, it just minimizes the chance of that happening. It will still happen at some point probably, but it just makes it easier. Shannon?
It's probably also worth, just because if the local authority has approached the very first interaction like this with verification and stuff, what I would say it's probably worth getting all the information you possibly can about reasons you could potentially be in priority need if that's relevant. So any sort of medical information around any struggles you might have, anything that makes you more vulnerable than the ordinary, healthy, robust person, which is not my words, it's like legal words. But I would start getting the evidence for that. I'd start going to the GP, making sure things are on record, and if it is relevant to your case, obviously, I'm not saying fabricate it, but just getting evidence possible because it sounds like it might be a rough journey throughout.
Yeah. Um, I'm just trying to line something up for the next question. Hopefully that's kind of dealt with that question there. But any professionals out there as well, just to say, if you're part of the verification process, like just kind of spend a bit of time reading what the law actually is, because you may well be inadvertently being part of the problem. Reason I'm trying to find something is because there's something else. So the questions, let me just get the question up. So it's about kind of entitlement to a kind of two bed if you've got a carer, which is quite a common issue. I have seen LGSO decisions. So basically, the database I've kind of put up there. Oh, by the way, Tiff, I put the direct link to that case I was looking at in the chat, so have a look at it. But yeah, the database is I'm kind of adding to it all the time, so I don't think it's been updated fully yet. but there is something I'm sure in today's something about carer, and I was trying to find it now. So if you sign up to the LJO newsletter, you get an email every lunchtime on a Thursday. I'm sure there was something into that. I might not be able to find. Oh, here we are. Yeah. Here you go. So now I think in this case, the person wasn't successful in getting an extra bed, but again, the LGSO decision will kind of go into the kind of things which should be looked at by councils. They help you understand how it should be done. So here it is. I'll put the link into the chat as well. Do that in a minute. So yeah, London Borough of Harrow. What happened was Mr. D complained about the council not carrying out repairs to the TA, which is again relevant to the question we had earlier. But also, have I just done the right one? Oh, yeah. So, and about his decision not to award him an additional bed space for a carer. So again, although it might not have been successful, the LJ will set out, kind of what the criteria would be for having an extra bed for having an extra room for a carer. So yeah, yeah. I'm not going to be able to read it all kind of here, but effectively, if you have a look at this, if you look through this decision, you're going to you'll get a better answer than what I can give, basically. So he got £300 compensation for the delays to repair, but it sounds like he wasn't found to be right about the carer because whatever the council kind of did the right thing or whatever. So yeah, hopefully that's probably the best way to answer that question. I think is just to kind of look at that link. So where are we up to?
There's
Oh, yeah, go on,
Sorry,
Shannon.
just to add in a little bit, there's also some information on carersuk.org. And typically it's quite a high threshold, so it's sort of regular overnight care where it's required, like it has to be sort of done, and it has to be overnight care, so it can't just be like a carer has to stay overnight, like the care has to be done overnight. And it also will depend on what other benefits you're on, so like what rate of PIP you're on, and similar benefits. So it's quite a high threshold, particularly because sometimes living rooms can count as bedrooms. So it might be that actually the local authority would say, well, you have an extra way that a carer could sleep because they could sleep in the living room. So you don't need an extra specific bedroom as we know it. So yeah.
Yeah, cool. Thanks, Shannon. Next question. There's the regulator of social housing. Is the RSH better than the Ombudsman in outcomes, please? So my first answer is I don't know. So first thing to say is that there's at least 3 ombudsmen I know of. There's probably more. So there's the local government social care ombudsman, which in the context of homelessness, we'll be looking at, did the council follow the right process? Did they look at the right facts? Not whether did they make the right decision based on those facts. It's a subtly different issue. You've also got the housing ombudsman, which looks at particularly council housing, but not just council housing. And what often happens is people basically complain to the wrong ombudsman. So what you often see on that newsletter every Thursday lunchtime is the LGO will say we will not investigate this complaint. That is because it is outside a remit. It's the housing ombudsman's remit. Now the housing ombudsman, I've had very little dealing with them, to be honest. I've got no reason to think they're really much different from the LGO in terms of the way they do things. They also do useful reports. So they've done ones on damp and mold, which have been very helpful in kind of my sort of casework over the years. Now, what the regulator of social housing is, I don't know. I don't know if Karis or Shannon know what it is better than I do, but I don't know whether they investigate complaints. I'm not sure what they do. I mean, they sound important, don't they? But I don't know if they are. Karis?
Yeah, they're about publishing information provided by tenants, facilities and services and non-compliance. So the regulator is supposed to work with the housing ombudsman. So ombudsman deal with the complaint things and they prepare and publish reports, memorandums of understanding, and they must work together and do like a joint up. The proposal is to join up. They must consult each other with schemes and standards. So they kind of work like that. It's kind of the regulator is more about the regulations they've like have they applied to this and stuff like that. The ombudsman's more about a complaint. I would say, and I would say you're better off going to the ombudsman, but it is your choice. And there's no harm in going to both.
Yeah, I
It,
mean, yeah. So because if you go to the wrong one, they'll just tell you. But
yeah.
so they'll just say, oh, you need to go over here instead. Um, Next one. Oh, what am I doing here? So this person is helpfully. Oh, this is nice. Yeah, whoever this is, thank you, because they basically put the fact that this is 1 out of 2. So it just means that I can follow it easier. So thanks for that. What happens when the LGO draft decision is close in a case involving street homelessness and unsuitable temporary accommodation that's worsened someone's physical health and led to a new medical condition? Warnings were ignored and the council held false info, only corrected after a SAR. Housing is now resolved. What remedies can be expected? What's the process now? So, um, fair play for getting through this process, whoever this is, because yeah, it's good that the situation's sorted. Now, what I'm now looking for is LGO guidance on remedies. And those wondering why I sometimes say LGSCO and why I sometimes say LGO. It used to be called the LGO. It's now called the LGSCO, Local Government Social Care Ombudsman. But I'm stuck in my ways and it's easier. And their website's still lgo.org.uk. So let me just share this screen over here. So in terms of what you're going to get, or what you're likely to get, what the LGO will be looking at. Annoyingly, they don't publish. This used to be a single PDF, but now it's kind of spread over various web pages, which is not brilliant. But effectively, within this guidance, so let me put the link in. I'll put the link in the thing in a minute. But if you just search for LGO guidance and remedies, you'll find this. So you get like introduction. You then get basically remedies which are common to all different areas, and this is where actually some of the answer will come here, because if you've got somewhere where someone's actually suffered specific harm because of the fact that the council failed, then there will be something in here, I think. I mean, yeah, I probably shouldn't say forget the apology, but they're just words, aren't they? Whereas what we really want is putting the stuff right. So one of the things they can do is basically get the staff on training, tell the council to train staff better. But somewhere down here, yeah, payments. And they are only symbolic, so they are much lower than you'd get anywhere else. But in effect, someone who has experienced distress and has now been harmed by it, um, then and you're going to be looking at these first two. In some cases, you might argue that there's been some outrageous stuff happening as well, so non-direct injustice. Um, yeah, so where someone's I'm not quite sure if that would apply or not actually. But if we could go down further, so distress basically kind of gives you the sort of payment range that they might do. So where we decide it is appropriate, we normally recommend a payment of for distress up to £500, which again, given that you might have some extreme distress because of the ridiculous failures of the council, that's not a lot of money. You've then got risk of harm, symbolic remedy of up to £1,000. So that will again, I've had one case where I went over that because the harm was so great, but that's unusual. So so let's say you're looking at something like £1,500 just for that, but you then also, we go back to the start, contents. You then look at the specific stuff, the homelessness or housing, and in here, so for example, it will say something like, you get quantifiable loss if you lost possessions or something, because the council should have done it. But your kind of baseline here is, so a recommendation for financial redress for being left homeless, in effect, is between 150 and 350 pound a month. Now, if you've been left rough sleeping, that would be 350 pound a month. Now, that's ridiculous in my opinion, because a family left in a B&B over the 6 week limit would be getting 800 pound a month. So, which is not, it just seems to me that rough sleeping is worse than being in a hotel for over the 6 week limit. So there are some questions, some complaints I have about these numbers. But let's say someone got left, they were left rough sleeping for 3 months, then you'd be looking at whatever that is, £1,050. And then, then you add it all together, and so you're looking at something, in those examples, you're looking at something like, whether it was £2,500 or so. There might also be a small element for the time and trouble of making the complaint, which seems to be if the council basically delay things and you have to chase them up for stuff. But yeah, so that's a starting point. You never know, as I say, isn't it? Yeah, but that's the kind of guidelines that the LGO will be looking at when they're calculating how much money to award. I mean, I've certainly seen cases where the complaint was absolutely legitimate, and yet the LGSCO still didn't uphold it because of sometimes they're a bit, in my opinion, been a bit flaky over the years. So yeah, have we answered that question? Yeah, that's all I can say. Anything more, Shannon?
Yeah, just to add, I guess, so like reiterate what Mike said about like fair fucking play for getting through this and getting this far. Um, I'd potentially as well recommend once the LGO decisions come back and that's all like done and settled, is going to your local housing committee or even the local full committee, which is made up of like councillors and head honchos at the local authority. And you can't bring individual cases to like a housing committee, but you could raise some of the like systemic issues that you might have faced, whatever that might be, whether it's, the unsuitable accommodation, whether it's the worsening and the treatment of an individual. You can raise it in that public forum, and basically ask for action and ask them what they're going to do about it moving forward. And you can sort of keep doing that. We've had quite good success in Bedford, making improvements that way, because it's you're increasing the accountability. So particularly if you're, say, disappointed with the LGO's response, which, there's not necessarily going to be a reason for that, but you might be, there's another way to sort of make wider changes.
Yeah, and I think if you're a professional and yeah, this might seem like an extreme position, but it really shouldn't be. If you're a professional and you've seen councils break the law and leave people homeless for whatever length of time, and a night sometimes is important, then I'd say you really do need to get down to your local housing committee and start asking questions. So that's just because it does make a difference. There's a few questions in here about the DWP, which we just don't know the answer to here. So we just don't know enough about the processes. So next question. So it's a two-parter, I think. I think that's just, there's another comment there, but I think this is the question here. So, what if a person with severe mental health problems living in a room in a HMO which is unsuitable would, for example, smash up the windows in the room? I do understand that the police will be involved. What about the eviction notice from the current landlord and the council's response in terms of alternative accommodation? So, yeah, I mean, basically, very bad idea, because the landlord will evict you, and the council will be very slow to help, and the council will, whether or not, I mean, let's take kind of really like severe case. You have someone who's got a literally psychotic episode, and they smash the windows in their room or something. But it was known that they were at that point having a psychotic episode, then they wouldn't be intentionally homeless because, in one sense, they lack capacity at that time. But it'd be it would be difficult to prove that because of the way capacity is assessed. So in this case like that, although the law would say, yeah, you're not intentionally homeless, it's still quite difficult to prove in practice. And so what I'd say is, that although there might be some way in which the council might have a duty to house someone in that situation, the reality is that the amount of resistance there's going to be is going to mean it's just not a good course of action. So I think it's easy for me to say because I'm not living in a horrendous HMO or anything, but you've got to play by the book. You've got to raise complaints again methodically, engage with counsellors, all that kind of stuff. That may not work, but other ways of dealing with things it's not going to it's not going to result in anything good happening basically. Plus, the landlord could basically end up, suing you for the money, and you have to kind of get money out of your benefits or something to pay for it. So yeah, it's just not a good idea. Technically, it is something which people can go to prison for as well, which again is not a good idea. So yeah, so I think easy for me to say, but if if your mental health's breaking down, you just need to not damage property basically. Shannon, you got anything to say on this one?
Yeah, I guess in an ideal situation, before it got to the situation where like windows are being smashed and stuff, it's worth approaching the local authority and making a homeless application based on it being unsuitable, um, to continue to occupy based on the effect it's having on someone's mental health. Because there's no denying that particular mental health problems, it would be inappropriate to be in a HMO. And so as long as you've got evidence that will back that up, and when I say evidence, not just GP, like you'll need like the local community mental health team, psychiatrists, psychologists, you need them to write a letter basically explaining why your housing situation is making your mental health significantly worse and it's exacerbating your mental health. And that's why it's unsuitable if you continue to occupy. So you'd make a homeless application and then obviously go through the normal route of, interim accommodation, temporary accommodation, and getting housed. And what I would say is obviously flagging that it's a disability, flagging any reasonable adjustments you might need to be made on behalf of yourself in terms of where your housing is, what it looks like, everything else. And then it also, if you are working with this person, I'd potentially recommend making a safeguarding alert. So if they are at the point where they are threatening to smash up the windows or whatever, like that's unsafe behavior. And they could end up harming themselves. And so it's not over the top to make a. I think we're so used to safeguarding alerts being when someone, says, "Oh, I'm going to do something really drastic and permanent," whereas actually this sort of stuff, it's a failure to protect themselves potentially. And the neglect and the mental health getting worse because of their living conditions. That safeguarding alert would help build your case, in terms of the homeless application, and potentially making a requesting a Care Act assessment as well, depending on the severity of the mental health problems and how much care and support needs this person might have. Because you can sort of get help from other agencies. It might be slow, but it's still worth doing. And again, it's all going to help that housing homelessness application, and help with things like not intentionally homeless and things like that if you've got this support around.
Yeah, yeah. It's a very difficult situation to be in. I'm just there was an LGSEO report I read recently. I can't remember what it was though, and it's not yet on the database. But there was stuff around kind of HMO accommodation and how it was considered. It wasn't particularly helpful, if I'm honest, but it talked about how the council should consider it. So yeah, I think I have a feeling this is a question that relates to the Section 204 appeal. So this is something that might already be in limbo. But yeah, I think yeah, go down the route to pursue more support rather than smashing windows. Yeah.
There's a further comment about this, just saying the person's not planning on doing anything inappropriate. It was just a
Yeah.
question. The
Okay.
person has all of those letters, especially from the psychiatrist. However, the
Yeah.
council's ignoring it,
Yeah.
making
Yeah.
excuses, ongoing for months. Yeah. Okay, waiting
Yeah.
for Section 204 appeal.
Yeah. Yeah. That's a horrible situation to be in. As I say, hopefully the Section 204 will come through and it'll be positive. Um. So next question. Um. Yeah, is quite a long one, but it makes sense. So this is one that's coming through the week. So I applied to my local council's homes back in February 2025 due to being autistic, having mental health and neurodiverse conditions, among other conditions, due to the fact that I didn't get on with my father and it was impacting my mental health. Under my homeless application, the council placed me in emergency accommodation in May 25 and then turned around and said that we think you're not in priority need in late June, as your supporting evidence only comes from private clinicians, despite them already giving me emergency accommodation the same evidence, only for me to make a change of circumstance request for my social housing application, which I had from years back, and for this team to award me Band B medical priority. The relief duty in time to appeal my homeless case is now passed, so I will not appeal the decision. But now the question is, where do I stay in the meantime? As my homeless housing officer has said that I will not be kicked out tomorrow. They were originally trying to discharge duty. Can they still try and force me into self-contained private accommodation, take away my Band B status? Or would they basically have to let me stay in emergency accommodation on a discretionary basis, despite the fact I'm not owed a main housing duty whilst I bid on property? So the question makes sense. It's an unusual situation, I think. But I guess we can kind of say a few things about it. One is that this thing here is council bullshit. Again, private clinicians are their evidence is often better than kind of stuff you get from the NHS. Um, you know, Will and Caris will be able to get significant amounts of money to pay for private clinicians to carry out assessments because they are worth so much. And there's plenty, there's countless case law where things have kind of been decided based on private clinicians or whatever. So that's nonsense. And in one sense, in a situation, in other circumstances, I get why this person's asking this question, but in other circumstances, it'd be a case of challenging it, or if you've missed the deadline, then just making a fresh application based on new information, which is almost certainly going to be there because of the nature that mental health issues kind of change over time. So, but yeah, going to the actual question at hand. So I don't know why the council would do this, but it seems to me that they actually might be trying to be helpful. Um, so if they basically said you're not in priority need, and yet they're continuing to provide emergency accommodation, as I say, that's they've done that under discretion. Not quite sure what's happening there. It might just be there's a very good housing officer behind the scenes, just kind of trying to do the right thing potentially. But in terms of so in one sense they can't make you at this point the homeless application is shut, so there's no main duty, or there's no final accommodation offer of private rented or anything. They can't make you go to private rented, but what they can do is they can they can basically rescind their discretion, or whatever the words would be. They can basically say, look, we're only housing you discretionally. You've refused this offer. We're now going to we're not going to continue helping you. So I would this would say to me that the housing officer involved is decent. Might be wrong, but I think they probably are. And I think you would probably ask them the question and say, look, how long can you continue housing me for? How long is it likely to take to get housed in Band B in this area? Because we don't know what area this is. It varies massively. Some areas it's only a few months, some areas it's 20 years. So that's something I'd kind of probably want to take into account as well. But yeah, so it's an unusual situation where the council's continuing to provide accommodation even though they have effectively ended the homeless application. And I don't know what else it might be. So that's just me speculating. But I think the only thing I can suggest is go talk to the housing officer and just say, look, what can you just explain to me what this all means? What's going to be my next steps? What do I need to do? And hope that they're going to be helpful with that. So yeah. Cool. Last question. Check I've not missed anything. Nothing. No, we're all good. So last question for this week. I'm melting a bit now. Is this one here? Oh, let's get rid of that. So I do not have enough points to and just to then this is actually a similar situation to this, so it might be a similar answer in some ways. So I do not have enough points to make priority to get a place. I have mental health, schizophrenia, and very bad anxiety that affects my everyday living. I live in a house of multiple occupation. I can't live with people. Can someone explain how I can get more points or be made more of a priority? Okay, so again, another sensible question. This actually kind of like there's a bit of an overlap between this question and the previous question, because I haven't really mentioned it yet. There are two parts of the Housing Act which matter, Part 6 and Part 7. And although they do interact at various points, they're very different things, but very confusingly, basically the way it's been set up is they'll use the same or very similar terminology to mean different things. So priority need, for example, is a homeless application thing. Priority points or priority banding is a housing register Part 6 thing. And so this person here, in effect, is in a situation where then they haven't advanced the argument that they're homeless. As Shannon was saying earlier, you're in a HMO, you've got schizophrenia and serious anxiety. There's a very good argument to be made that it's not reasonable to continue to occupy that property. Therefore, you are legally homeless. So one thing that I think the answer here is try and find a decent, competent charity worker that actually knows a bit about the law to help you through this, because it's very, very complicated, and it's very difficult to kind of get resolution. But if I was trying to help someone in this situation, I would potentially consider making a homeless application based on the fact it's unreasonable to continue to occupy. There would potentially be quite a lot of medical evidence kind of available, kind of assessments of the schizophrenia and so on. So that would be one way of doing it. If you're not going to make the homeless application, the only answer that we can give is you'd need to look at your local council's policy, because whereas homeless applications are always the same across England, the law is always the same, the rules are always the same. When it comes to housing register applications, the Part 6 route, every area is different. And so the only way you can get an answer is to Google your council's name and the term housing allocation scheme, and look at the small print of that to work out if they've given you the correct banding. And then try and work out, if you're, for example, should be band B and it's going to take 10 years to get housed under band B in your area because, it might be London or something, then you'd need to kind of maybe consider making the homes application, kind of like going down that route more. But again, difficult one to make. You need to find a competent advocate basically who can do it. So it might be you start with your CAB, your local CAB. Maybe they don't have any particular expertise with this, but they may well know some local services that do. So there are professionals out there who would be able to kind of work this out. So yeah, that's my answer to that. Anything else from Shannon and Karis on that one? As I say, yeah, hopefully that made sense. I think that's it. So yeah, so Tiff, I'm not quite sure what you can see, but so yeah, I don't know. I'm not sure if YouTube's misbehaving, but as far as I can, I mean, I can only see what I can see. So there might be stuff in there which in the chat which I've missed, but I don't think I have. So I'm not quite sure why you're not might be able to see it. So yeah, I think that's it, guys. So any further questions that you've missed tonight, stick them on the channel. Any video on the channel, stick them as a what if question. We'll answer them next week. My guess is that Will won't be on live streaming on Monday. I might be wrong, but because I think the heat wave is going to continue through to well into next week, basically. I don't know if any of you guys caught the live stream we did on Tuesday, but we might do some more of them at some point. So I enjoyed it. Someone in America didn't enjoy it for some reason. Got very annoyed with us, but yeah. So keep an eye out for that. Other than that, guys, hopefully this has been helpful, and yeah, we'll hopefully see you next Thursday. We'll be back here next Thursday. Whether or not we'll be here on Monday, I don't know on Will's channel, but we'll see. So yeah, take it easy, guys, and just keep going. Basically, hopefully it's been, as I say, hopefully.